not showing. Down, got that.
Would it be better if I use this input?
No, here we go. All right. Okay, it should be your,
I'm connected to here.
yeah. That should be you.
I can switch it to mine. Let's see if that may work, or to this desk here, council table.
Okay, well, we're not getting anything.
There we go.
Okay. All right, I just blacked it all. All right. Nothing for the nothing on the record on behalf of council.
Not from the state, Your Honor. Thank you. No, Your Honor.
All right, Mrs. Harper. No. The file cabinet. Gloves.
Medium or large or small?
Fine, we'll make it work.
All rise for the jury. May be seated, ladies and gentlemen. All right, good afternoon.
Good afternoon.
Excellent. All right, ladies and gentlemen of the jury, Okay, you have heard all the evidence that you're going to hear in this case. Okay, at this time, we're going to move to closing arguments of counsel. Closing arguments of counsel is not evidence. It is information that hopefully will help you as you are deliberating. Because the state has the burden of proof, the state will have 2 opportunities to close. So on behalf of the state.
Thank you, Your Honor. Ladies and gentlemen of the jury, I want to thank you for your time and your attention over this past couple of weeks. It's very important to us that you have shared essentially your lives with us so we could present this case to you. The case of State of Ohio versus Adam Coy. As you know, Adam Coy shot and killed Andre Hill. Andre Hill was born on May 23rd, 1973. He would have been 52 years old. He's not here for us to sit in between counsel tables, so I ask you to follow the judge's instruction when the judge says don't be weighed by sympathy or prejudice. We heard a lot about what happened this night on December 22nd, 2020. This case isn't about someone who is resisting arrest. The officers piled on him, put a knee on him or something like that, and he dies. This case isn't about that. This case isn't about someone who, shoots at the police, is involved in a high-speed chase and runs and flees from the police and is shot as a result of that. This case is not about someone who tells cops, I hate you, I'm going to stab you, I'm going to shoot you. It's not about that. It's about a man who was following police orders and was killed for it. We heard from Robert Ronker, Mr. Ronker. He was a 911 caller. He kind of set the events in motion. After Mr. Hill got to this address on Oberlin, he was that first house that you viewed in the jury view, and some of you were walking up the driveway and that sort of thing. That's where he lived. He saw Mr. Hill's vehicle there, didn't recognize it. Vehicle had been turning off and on for hours, so he called the cops. They actually relayed him to the police officer, the police number instead of 911, because it was that low level of an emergency. So when police officers get there, Mr. Coy, he gets there. You heard from Mr. Ronker that, he told Mr. Coy that the vehicle that he was after or that he was looking for was parked down the street. And he goes out and tries to tell Mr. Coy something. Mr. Coy shoos him back to his residence. And then he says he hears the shots. You heard from Amy Detweiler, Officer Detweiler. She stated that she was been Adam's partner for her entire career. She had worked with him, worked around him. That she arrived on the scene shortly after he did, a few minutes later. Didn't notice anything weird. Thought that Mr. Hill was maybe sleeping in the vehicle or something like that. And then Coy says to her, something's weird. That's really all he says. Something's weird, something's off, something like that. And then they approach the garage. And they see Mr. Hill in the back of the garage. They shine their flashlights on him. You heard from her. And she said, come on, or Mr. Coy said, come out, show yourself. That's exactly what he did. He showed himself. And he shot 4 times. You heard use of force experts testify that an officer is responsible for every shot that they fire. Every shot that they fire. That when using force and evaluating how much force is necessary, they're supposed to evaluate what is happening. If it's too much force, ratchet it down. If it's not enough force, ratchet it up. But Mr. Coy shot and killed Andre Hill. You heard from Officer Ben Bradford, who said that he arrived on the scene a little bit later, didn't know what was going on. No one told him what was going on, didn't know what he was walking into, and was there, just kind of standing around. Then an officer came by and said, pump his chest. So Officer Branford, got on Mr. Hill, started pumping his chest, attempting to use life-saving measures. Until the medics arrived. You heard from Paul Hill, medic. He arrived, started pumping Mr. Hill's chest. Then they took Mr. Hill away. And the medic. You heard from Asia Chung. She was the crime scene search unit detective. She took evidence, she took photographs, as she does in your usual course. She didn't see what happened on the scene. She located some shell casings. But she collected the evidence of this officer-involved shooting. You heard from Dr. Daniels, Dr. John Daniels, who is a pathologist who does cases here in Franklin County, Ohio. And he testified that Mr. Hill died as a result of gunshot wounds. He testified to that, and that was his expert opinion. Then you heard from a use of force expert by the defense, Kevin Davis. He essentially looked at this case, determined that all of Mr. Coy's actions were within sound police practices. There was nothing wrong with them, that they were just fine. You heard from the defendant who testified. He testified as to what he says he saw and what his impressions were when he saw Mr. Hill coming out of that garage. But we keep coming back to the fact that fear does not equate to threat. Mistake does not equate to threat. That's where this boils down. We can't look into the mind of him. I can't open his brain and determine whether he was actually fearful or not, whether he was actually scared or not. But it actually doesn't matter. What matters is, would a reasonable officer on the scene at that time use that force? Use deadly force? And the evidence has shown that a reasonable officer would not have. You heard from use of force expert James Scanlon, who essentially did the same thing. He took Mr. Coy's statement, worked his way backwards, and justified the use of force by Mr. Coy. Said, yeah, it's sound police practices. Yeah, it's fine. Yep, it's all fine, what he did. The state put on a rebuttal witness, Seth Stoughton, who testified, yeah, a police officer can use deadly force if someone points a gun at them. Would you? He would lose all credibility if he said someone could point a gun at a police officer and a police officer couldn't use deadly force. But we got to look at the context. We've got to look at the surrounding circumstances. And when you do that, when you apply that to the law, Mr. Coy's guilty of the charges. Let's talk about those charges. We look at the offenses. Did the state prove beyond a reasonable doubt that the defendant committed the offenses? We go into murder. Again, you're going to have jury instructions that the judge is going to read to you and give you a copy when the attorneys are done talking. So you'll have that. If you want to take notes, go ahead, but you'll have the full definition. These are kind of like bullet points here. This causing death as a proximate result of a felonious assault. That is what count one is. There are a lot of different classifications of what we call murder. There's probably about There's a lot, more than just one. This is the one. This is the offense that the defendant has committed. So don't get caught up in the title. Focus on the elements. So did he cause the death of Andre Hill? Yes, he did. Hopefully I don't have to spend too much time on it. It's on video. He caused the death of Andre Hill. He did not do it accidentally. He didn't drop his gun and the gun go off and it shoot. Yes, he did claim mistake, but that's different than accident. So he caused the death. As a proximate result, the defendant is responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. As a proximate result of committing a felonious assault. So the defendant committed a felonious assault, and that caused Mr. Hill to die. What is a felonious assault? A felonious assault is causing serious physical harm. That's one way to do it. And I would submit to you that getting shot 4 times is serious physical harm. Or you can cause any physical harm with a deadly weapon. So this is an and/or type of definition. Serious physical harm or physical harm plus a deadly weapon. A deadly weapon is a gun. Deadly weapon could be a pipe, pole, knife, any of those things that can cause death. Here we're talking about the defendant's weapon. Cause of the death of Andre Hill. Count 2, felonious assault. You will be asked to decide if the defendant has committed that offense. The evidence shows that he has. Again, this was no accident. This was no accident. He has said he is mistaken, but it was not an accident. He caused serious physical harm, and he caused harm to Andre Hill with his deadly weapon. And reckless homicide. Recklessly causing the death of another. Recklessly causing the death of another. His actions were reckless, ladies and gentlemen. They were reckless. From the time he got out of that police car to the time he walked down that driveway, everything in between was reckless. What was really reckless was shooting an unarmed man after he had just gotten out of a car, and he shoots that man, and his justification is that man had car keys that he thought was a gun, that he says he thought was a gun. Now, if you find that the state on any of those charges has proven the defendant guilty beyond a reasonable doubt, then we move to their justification. I know some of you are thinking, well, how can a police officer be charged with, with felonious assault and killing somebody and reckless homicide? He's a police officer. They're supposed to get dispatched to scenes and shoot bank robbers and things like that. How can they be held responsible for these types of things? Because we expect them to do that. Yes, but we only expect them to do it in situations where it's reasonable. So, after you've seen the video and you've seen the evidence, the state has proven those bare elements, those elements of the defendant committing those crimes. Now we move on to the justification. Was he justified in his role as a police officer to do what he did? And when we look at whether he was justified as a police officer to do what he did, we look at the reasonableness aspect of it. The reasonableness aspect of it. And it is the defense's burden, not ours, to show that he acted reasonable or not. State feels he's not acted reasonably. The evidence shows that there has not been anything or enough shown in trial to prove by a preponderance of evidence that the defendant acted reasonably. heard about in voir dire, what does preponderance of evidence mean? That means more than not, 51%. So if you're really not sure, then the defendant has not met his burden. They have a burden to prove to you. They have to prove to you that this was justified. They have to prove to you that it was reasonable and that a reasonable officer would have done the same thing. And that's outlined in your jury instructions. Test for reasonableness is an objective one, not a subjective, not what that individual thought in their own mind is what a reasonable officer would have thought. The question is whether an officer's action was objectively reasonable in light of all the facts and circumstances confronting him without regard to his underlying intent or motivation. So, did the state prove beyond a reasonable doubt that the defendant committed the offenses? I believe the evidence shows that it has. The video shows that it has. He did not do it by accident. He knew what he was doing. He knew that when you shoot somebody 4 times center mass, whether you classify it as stopping the threat or something else, the person is likely to die from it. And I get it. Officers are trained to shoot center mass. I'm not saying that he should have shot a limb or a foot or anything like that. I'm not saying shooting center mass is not what he was aiming to do. He was aiming to shoot center mass. And when you do that, you can reasonably conclude that someone's going to die from getting shot center mass. So again, the evidence shows that the defendant has committed the crimes of murder, this category of murder, which is causing the death of someone as a proximate result of committing that felonious assault. Once you have found that, then you move on. Did the defendant prove by preponderance of evidence that he was justified in using deadly force? You move on to that other item of justification. If no, if they have not proven by preponderance of evidence, then your verdict should be guilty. If yes, if they have proven by preponderance of evidence that this officer was justified in what he did, then we move on to not guilty. And that applies to each of the charges. And if you find that the state did not prove its case beyond a reasonable doubt, then your analysis stops there. You don't even have to move on to their preponderance standard. The state has presented evidence of Mr. Coy shooting and killing Andre Hill without justification. You've seen the video. You will have the video and evidence. The things that Mr. Coy says about that interaction that night, they're not really supported by much at all. Blading, Mr. Coy classified it as being in a boxing stance. You don't see that on the video. You see Mr. Hill following police orders, walking to where he was called, with the flashlight in his eye also. So if you've ever been in a dark space, I'm sure all of you have, and someone shines a bright light at you, that's going to obstruct your vision a bit. That may impair how you're walking to someone. But he wasn't stumbling or falling or blading. We'll be able to see that from the video. This is a man just walking. As I talked to the defendant while he was on the stand, we had an exchange. And that exchange was because the evidence shows that the defendant shot and killed an unarmed man following police orders, and then he had to work his way back. He said moments after the shooting, he says, I gotta find what I missed. That's what he said on the stand. He confirmed that. Those weren't my words, those were his. I gotta find what I missed. This is moments after the shooting. That's when this started, ladies and gentlemen. Moments after the shooting, he said, I know I can't just shoot an unarmed man for no reason walking out of a garage. So what are the things I can point to justify that? He wasn't concerned that a burglary was happening. He wasn't concerned that there were hostages in that house. He wasn't concerned with this. He saw Mr. Hill waiting. That was perfectly normal to him. He was fine with it. He was going to wait till Mr. Hill left and then call it in and travel somewhere else and finish his lunch, as he told you. And Officer Detweiler arrived and he goes, better do something about this. So let me go and see where Mr. Hill is and what's going on. He sees Mr. Hill in the garage, orders him out, and then for whatever reason, a reason that none of us may ever know, he decided to shoot Andre Hill 4 times, kill him. And then he goes, oh, fuck. He says that. He says those words. Because he realizes he had no justification. There was no reasonableness to it. And when he goes down and he's talking to Officer Barsati and he says, I gotta find what I missed. That's where this starts. I talked to him. What did he say that was weird? What did he say that I can say was weird? He comes up with these things you can latch on to, that he can sell to you. It is tragic, ladies and gentlemen, all the way around. It's tragic. I'm not trying to tell you that this defendant woke up this morning saying, I'm going to kill somebody. I'm not saying that. I'm not saying that he's the worst human being on the planet. I am not saying that. I'm not saying he's a rogue cop who goes out and he kills every potential person he comes into contact with. I am not saying that. I'm not bringing that to you. We look at his actions, and he killed an unarmed man and didn't have reason to. And that justification defense he made up after. Ladies and gentlemen, when you get this case, look at what I'm here. Look at all the evidence. And when you do, you will find him guilty of all of the charges. You also find that the justification defense, it's not common sense. If you follow your common sense, it just does not fit. Thank you.
Thank you, Mr. Pearson. On behalf of the defendant?
Your Honor, I'm going to need the ELMO.
Okay.
You want to set that first? Perfect. Your Honor, may I proceed?
You may.
Thank you very much. May it please the court, Madam Court Reporter, Adam, Ms. Stevens, Mr. Pearson, Ms. Amlin. Good afternoon, ladies and gentlemen of the jury. Good afternoon. I'd like to thank you as well, a little bit different thank you. You stood up in the beginning of this process when the judge swore you in, and you took an oath not to form any conclusions or form any opinions until you heard all the evidence, until you've seen all the evidence, all the arguments, and the judge's instructions. Now, as you know, we've been a bit busy, but we've tried to watch you, and I do believe you've kept that oath. And for that, I thank you, because without you keeping that oath and performing your civic duty, we wouldn't have the best criminal justice system in the world. I thank you for that, and I appreciate it. Closing arguments. Put the government's case to the test, show you what our case is about, ask the tough questions. We now know what the government's theory, that somehow he shot an unarmed man and made the entire thing up after the fact. Okay. That's perverse, ladies and gentlemen. That's desperate, ladies and gentlemen. That's the government, ladies and gentlemen. Ms. Stevens told you in the opening that the theme of this case is one of reasonableness, one of justification, all right? One of a mistake was made and whether or not that mistake was reasonable. That's what this case is about, ladies and gentlemen. I'm going to do my little chart again that you saw in openings. I'm going to leave that up there. Can everybody see that okay? So this case is about the situational need to use deadly force, not for an unknown reason, not for something that's kept secret, because he saw a deadly threat. He perceived a deadly threat. So this case is a bit different, but it's very simple, ladies and gentlemen. It's very simple. It's a different analysis because first, as the chart says, you have to analyze whether or not the state proved beyond a reasonable doubt each and every element. Specifically, what did we tell you in opening, in voir dire? Mental elements, okay? No one's challenging the date, the time, the county of Franklin, it was Mr. Hill, it was Mr. Coy. Those are the other elements that they must prove. The only thing that we're challenging that the state did not prove beyond a reasonable doubt, proof of such nature to rely upon it in the most important of your own affairs, surgery for a loved one, care for a child. Okay, the mental elements. Recklessness. They have to prove recklessness beyond a reasonable doubt. At what point in this trial did you hear the term reckless ever used by any of the witnesses by the government, including Seth Stoughton? At what point, ladies and gentlemen, was there any evidence that our client was reckless? Recklessness, the mental element, is a heedless indifference, disregarding a known risk. Okay, disregarding a known risk. There's no evidence of that. They haven't provided that. Recklessness, ladies and gentlemen, is different than knowingly. They put two theories of the case up on a board because they don't believe in their own case. Knowingly standard is a different component than recklessness. I'd submit you can't have both at the same time, ladies and gentlemen. When he decides to pull that trigger, you can't have recklessness and knowingly at the same time. They're competing. Now, what he didn't tell you just then about the mental elements, because he didn't go into them, is that at the time my client fired, what was his intent? The next step is everyone who testified from the Columbus Police Department, the two experts, what are they trained to do? I asked every one of them. Are they trained to injure? No. Are they trained to kill? No. They're trained to stop the threat. If they fire once and miss and the threat stops, that's what they're trained to do, to stop the threat. They don't form the intent to cause serious physical injury with that. Mr. Pearson just said, oh, yeah, I'm not asking them to shoot a limb or something like that. That's exactly what he's saying. They don't form that intent when they fire their weapon. That's not what they're trained to do. They don't form a reckless intent when they fire the weapon. They're trained to react to a deadly threat, and that's the only time you can, ladies and gentlemen. A perceived deadly threat. What known risk was put out there by the government in its case in chief? There is none. Zero. Throw both up there. Hope you guys will compromise and go to that. Look at their witnesses. Their own witnesses show that it wasn't reckless or that it wasn't that it wasn't knowingly. Why? Officer Detweiler, what did Officer Detweiler tell you? I said, had you perceived the same threat, what would you have done? She said, I would have shot. I would have shot. She couldn't see that side of the body. That's why she didn't shoot. Had you seen that, everything about Officer Detweiler, was there anything reckless about her testimony? Was there anything reckless that she did in that situation? Because she said I would have done the exact same thing. Did you believe Adam Coy thought, an honest belief that he had a silver revolver in his hands? Absolutely, she said, 100%. Now, don't just listen to her word. What about Officer Brantford? Police tactics. Officer Brantford, remember, was sent out on a robbery run, lights and sirens, right? He's heading up there. It turns out it was a domestic disturbance, something a lot lower. What do I ask him? Hey, had you been encountered someone who presented a deadly threat to you, would you have fired? He said, absolutely. That's what we're trained to do, to stop the threat, not to injure. And there's nothing reckless about what he said as well, ladies and gentlemen. That's their witnesses. Now, ladies and gentlemen, if they don't prove their case and it's a no beyond a reasonable doubt, you stop there. It's not guilty. Right? We all agree on that. All right? If for some reason we don't concede that you do believe that they prove their case beyond a reasonable doubt for the mental elements, then you have to examine our burden, okay? Our burden. Whether or not we prove justification beyond a preponderance. And again, how about Mr. Stoughton? Beyond a preponderance, he acted like he'd never heard the term before, and he's a lawyer, and he teaches law students. More likely than not, ladies and gentlemen, he didn't know that that's the standard in Ohio to judge a mistake. That's why he told you, oh, gee, more likely than not, oh, geez, I've never heard it that way. Because he doesn't know the law in Ohio. One smidge over 50, it's not 51%, it's more likely than not a tipping of the scales, ladies and gentlemen. And please hold us to that standard if that's where you are in your analysis. We have to prove two things. More likely than not, that Adam Coy had a subjective belief that he was in imminent fear of serious bodily harm and injury. Okay? It's not afraid of the situation, ladies and gentlemen. It's an imminent fear of receiving bodily harm or serious physical harm or deadly threat. That's what the fear is. And you heard Kevin Davis say there is no greater fear than someone leveling what's perceived to be a weapon at an officer. And the best part about the government's rebuttal case is no matter how Mr. Stoughton defines threat, ability, opportunity, intent, you won't find that in the jury instructions, ladies and gentlemen. You won't find it. That's why Mr. Scanlon and Mr. Davis said, do you agree with his report or not? Well, I agree with parts, but not parts, because he makes up his own standard. He makes up his own definitions, because he's got to create that in order to start from a premise and work backwards. The second thing now that we have to prove is more likely than not was the decision to use deadly force reasonable based on the totality of the circumstances from a reasonable officer at the scene in his or her shoes, experiencing what they perceive, not what could have, should have, would have done with hindsight of 2020, but could have believed the need. That's the issue that you examine more likely than not. All right, let's go through and let's talk about our burden, okay? Let's look at the first prong. The first prong we have to prove, more likely than not, that Adam believed he was about to be shot at. Okay, it's that simple, all right? We have proven that more likely than not, ladies and gentlemen. How? He had a subjective belief because he told you. He told you he believed and perceived a gun was coming, okay? So that's one way we prove it. How is that corroborated? He announced it. He announced, gun, gun, he's got a gun. No matter how much they want to say he made up a story, he announces it, and Amy Detweiler hears it before the shots. Do you honestly announce something if you don't perceive it? So was he actually lying from that part as well, knowing that he was going to shoot an unarmed man and announce gun, gun? That's how preposterous their theory is. He tells you what he sees, he announces it. we have proven more likely than not he had a subjective belief that he was in danger of serious bodily injury or death. That's the first part, his belief. All right, second part, all right? Now, the second part is bigger. It's bigger than what Mr. Pearson made it out to be. It's bigger because it contains multiple things about reasonableness, okay? So, we know in hindsight that there was no weapon, correct? We all agree. We know in hindsight there was no weapon. So now we have to look at the totality of the circumstances. You have to put yourself in Adam's shoes and determine whether or not the mistake is more likely than not reasonable. Now, we'll go over the police terms for that, but just using your common sense, when you put yourself in those shoes, was it reasonable using your common sense? It's pitch black out. You can't see in that garage. You see the body-worn camera, how dark it is, okay? There is no light on. It's almost 2 a.m. Close confines. Not a lot of room from the car to the other side. Duty to investigate. No matter what Mr. Stoughton says about a person in a garage that they don't have the ability to investigate, every single police officer told you that they had a reasonable suspicion to investigate in that situation. You can't see the full body. There were commands given. There was partial compliance. There was a left hand up, not the right hand. There was blading, and I'll get to the body-worn camera, ladies and gentlemen, but remember, the body-worn camera only had a certain amount of look back. Adam and both Officer Detweiler described for you many events that happened in the back of the garage that aren't on the body-worn camera, okay? That aren't on the body-worn camera. And I'll get into that of what a camera sees versus a human eye sees. Using your common sense, bladed, okay? Did at any time prior to this, to Mr. Hill coming to the car, did my client pull his weapon out? No. At any time when he said, hey, where you going? Come back here. Did he pull his weapon out and draw down on him? No. He wasn't reckless. He was reasonable those times. And an entire interaction. Once he sees, ladies and gentlemen, the glint of steel, that's a term because it's a Supreme Court term. And Mr. Professor's like, oh yeah, I think it's in one of those cases. You don't have to wait to see the glint of the steel. My client saw the glint of the steel and reacted, ladies and gentlemen, reasonably. Was the mistake reasonable? Use your common sense. Ms. Allen, may I trouble you for the keys? What else using your common sense? Government doesn't show you these keys, ladies and gentlemen. They don't show them to you. When you untangle them, we had to measure 8.5 inches. We had them plumped and stuff like that. Okay? Common sense. Just using your common sense. Do you think these could be mistaken in the hand of a person as the hand comes up? We can't tell you how they were being held. We can't tell you if it was a clump. We can't tell you if this was there. Okay? But is that a reasonable mistake based on these keys? If they were all black, of course not. If there was no metal or silver, of course not. Okay? And remember, they're missing 2 things here that were given back. Using your common sense, ladies and gentlemen, is the mistake reasonable? Their own expert admitted, well, yeah, in hindsight, he had the keys in his hands. Okay. They're silver, they're metal. Regardless, compare that to the picture of the revolver I told you. We talked about this in voir dire, the difference between a semi-automatic, shotguns, and revolvers. I showed you a picture of a silver revolver. Most of it's silver and about the same length, depending. And what did Adam describe? I saw a short thing with a bigger thing in the back. That's what he described. Is it more likely than not a reasonable mistake? Now, if he said, oh yeah, he had a black semi-automatic in his hand, or he had a gun in his, a semi-automatic in his hand, or he had an Uzi, or he had an AK, or so, of course that wouldn't be reasonable, ladies and gentlemen. Of course not. here's the best thing. What have they shown that it's not reasonable? How is the mistake not reasonable, ladies and gentlemen? We've shown way beyond a preponderance, more likely than not, that the mistake was reasonable based on based on this, based on his statement, based on gun, okay? Based on Officer Detweiler saying, absolutely, I would have shot had I seen that. We have proven more likely than not. What else, though, ladies and gentlemen? His belief that he had a gun. And again, this screws up the state's theory that he made it all up after the fact. What else? Because he says, get back to Officer Detweiler. I can't see his hands. He's still got a gun. Find the gun. Find the gun. Why do you tell somebody that if you don't believe there's a gun in his hand? You don't. You don't yell gun, and you don't tell someone, hey, wait a minute, get back. Now, that's not just his statement on the stand. That's Amy Detweiler's remembering and perception. And it's backed up by the body camera. You hear it, and so you get back. Don't get him until that. Those are all corroboration that Adam's belief that he had a silver revolver in his hand, ladies and gentlemen. And yes, he's mistaken about it, and that's the hard part. We're asking you as a jury, the hard thing to do when there's no weapon, that there was no weapon in hindsight. So remember we talked in voir dire, we ask you to be a clinician. That's a hard thing to find that someone made a reasonable mistake when there's no gun. If there was no anything there, okay, they got an argument. If there's nothing there, their own expert says, hindsight, he had keys in his hand. We know the keys are there. Ladies and gentlemen, the judge will tell you the objectively reasonable officer can be mistaken, even if he had a mistaken belief. As long as that mistaken belief is reasonable and none of the then existent circumstances, the officer is justified in using deadly force. If an officer reasonably but mistakenly believed the individual posed a deadly threat, the officer would be justified in using deadly force. So I'm not sure what he doesn't understand or what's hiding or something like that. It's been no hiding that our client did a voluntary written statement, a voluntary interview. He testified in front of a family, in front of the people, in front of 15 strangers about what he went through. And they don't believe it's reasonable? Now, there's other things that the judge will tell you, like Ms. Stevens said in the opening. The judge is going to tell you that actual possession of a weapon is not relevant, as long as the officer reasonably believed the individual possessed a weapon. The law does not require officers to wait until an individual uses harm or starts to use harm or confirm that a serious threat of harm exists. There is no checklist to say, oh, I got to wait a certain amount. I got to wait to see if there's just an actual serious threat. No, that's not how they're trained. That's not how they're trained. Because as a society, we don't want them to make mistakes because we know that a mistake can be deadly and tragic, just as this case is. We know that, but we put officers in impossible situations. We put that family in an impossible situation to tell them about justification. And we put you guys in a difficult situation because there is no weapon there. It was a mistake whether or not the perceived deadly threat was reasonable, whether or not the mistake was reasonable, ladies and gentlemen. That's exactly what we have here, what the judge will read to you. So Mr. Stoughton and his creations, those are distractions. And I understand, ladies and gentlemen, it's a tough law to follow. We talked about that in voir dire. It's a tough law to follow. Okay, but that's the task that you have, and we all trust that you can do it and follow the law. Moving on to the second prong of justification. Second one, remember, decision to use deadly force was reasonable, given the totality of the circumstances based on the eyes of a reasonable police officer on the scene. Now, you're going to hear that over and over again in the instructions. So I'll get right to it. Is it more likely than not that his force was reasonable. The state put up 2 witnesses that both confirmed that. The first, Amy Detweiler, how she was trained, the stuff that she goes through, the shoot, don't shoots, the train to stop the threat, actions faster than reaction, you don't have to wait. All of those we went through with both Officer Detweiler and Branford, their witnesses. And both of them said if they perceived a deadly threat, they would fire. That's their witnesses, ladies and gentlemen. I hope you believe that Mr. Branford, or Officer Branford and Detweiler were credible. How credible was Officer Detweiler when I went to show her the picture of the keys? What'd she say? She goes, I don't recognize those. Okay. She's not gonna talk about them because she doesn't recognize the picture. Okay, and that was our part. That's someone who's telling the truth and who's credible. And what did she tell you, ladies and gentlemen? She told you that enough. They talk about this lack of communication. Amy Detweiler gets out, goes 10-4, meaning, no. She had seen the person walk away. Nothing's making sense. Something's weird. What does she do? What does Amy Detweiler do at that instant? She pulls out her gun and gets it low and ready. That's based on her training and experience, ladies and gentlemen. But Seth Stoughton have you think, oh, no, it's okay. Someone wandering around a dark garage, oh, no, that's all right. The most credible thing Amy Detweiler said was, I asked her this, why didn't you shoot? Sir, we're trained if we don't see a perceived threat, we don't shoot. What could you see? I couldn't see the right side. I asked her how she felt about the cell phone. She goes, I felt like a fool because I fell for the distraction. They're trained not to. They're trained to keep looking at different things. She goes, I felt like a fool. That's someone who's credible. That's someone who's reasonable. She didn't see the right hand. She's not going to tell you unless she's sure, ladies and gentlemen. Well, what was she sure about? She was sure that Adam Coy believed he saw a silver revolver because he announced it, gun, and he told her, don't go up there. Branford, again, on a robbery call. And I asked him, if someone presented what you believed was a silver revolver, even though on the robbery call was something else, he would shoot. That's reasonable. Those are their witnesses, ladies and gentlemen. We provided you 2 witnesses, and I'll get to the witnesses more, who went over that. These experts, ladies and gentlemen, that we presented you, train officers. Their expert trains law students, okay? They all indicate that if you perceive a deadly threat, even the government's expert says, if you perceive a deadly threat, the use is consistent, the use of deadly force in response is consistent with national policing practices. Now, the state wants you to focus on a singular thing, ladies and gentlemen. What I mean by that is they want to take everything out of context. Well, he didn't use vulgar language with you, right? Or he didn't have to do this, meaning Mr. Hiller, have to do that. So let's talk about all these ambiguities that Mr. Stoughton goes through. And an important thing here, ladies and gentlemen, is the timing. What time is he sent out on the run? Like 1:30. Says he gets out there in 5 or so minutes, okay? What time does he run the tag? 1:45. So he's been on the scene, we know at least probably 10 minutes. What time is it aired shots fired? It's like 2:02. So from 1:35, ladies and gentlemen, 25 minutes puts you at 2, just after, okay? That's 27 minutes that our client encountered Mr. Hill and observed things. The end was very fast, yes, but keep that in the back of your mind, the time issue here. Now, I'm gonna walk you through from the time he got dispatched all the way to the use of force, okay? And you tell me, ladies and gentlemen, what you ask yourself, is this odd? Is this different? Would I want this type of police officer investigating? Is this reasonable? Ladies and gentlemen, he goes to a silver SUV. Turns out to be the wrong one. So is he mistaken about that? Yes. Thank goodness Mr. Renker calls out. Says, hey, it's not there. Okay. That's odd. It was here. Well, it moved. Okay. They go into the catalog. And Mr. Renker, what does he talk about? On the 911, hey, I'm not going out there. I don't have a gun. I'm afraid. I'm not going out there. It's all about what perspective you're coming from, ladies and gentlemen. So you have to put the totality of the circumstances. So, okay, no big deal. I got this. Go inside, he tells him, and he pulls up there. He doesn't pull up there in a half-ass reckless way. He pulls up there just as he's trained to do, offset behind. He approaches a vehicle that he's done thousands and thousands of times over his 18 years of service, ladies and gentlemen. And as he goes up, he's stopped because the gentleman, Mr. Hill, turns around to show him something. We asked, did that seem odd? Well, yeah, normally, Mr. Pearson asked him that. And he said, yeah, normally they don't say anything until I get to the window and I have to knock on the window. Okay, anything wrong about that? Anything suspicious? No, ladies and gentlemen. So, hey, she'll be right out. He notices white-eyed jittery. He's cataloging it. That's what Mr. Scanlon told you. You catalog these things. That's what they're trained to do. No singular incident here, ladies and gentlemen, in and of itself allows the use of justifiable deadly force, except when you get to the raising of the arm. But it's the ability to investigate, ladies and gentlemen, the reasonable suspicion. Okay, go right ahead. As he walks by the car, he sees there's a bunch of stuff in there. He sees that it's tinted. And so he goes in his car and decides the weight. Gee, I don't know, using your common sense, is that probably a good thing to do? To see if the person comes out? Yeah. Okay, he can't just take off. He's there on a run. He has a duty to investigate. So at that point in time, he runs the tag. Now, they make a thing out of it that, geez, he didn't ask his name and he didn't get his ID. There was no need to. He was doing nothing wrong. Yet, hey, good, you're good. And what did Mr. Coy tell you? And you know, he told him why I was there. Hey, I was here because I was dispatched on a vehicle. Yeah, I'll wait till she comes out, or I'll wait till the person comes out, right? So then the situation is, okay, nothing happens. Nothing happens. How long does it wait? We know he runs a tag at 1:45. Then all of a sudden, the individual Mr. Hill gets out of his car, goes in front of him. What does Adam do? He's not eating his lunch in the cruiser, not paying attention. He gets out and stands up as he's trained to do. He watches him. Now, is it odd that he doesn't go to 1070? He's parked on the furthest edge of 1070. Sure, it's odd. Sure, it goes into the calculation. Is it odd that he doesn't walk up the driveway to 1070? No, he comes and goes like this. Adam follows him. And he comes across and goes up. Okay. Has he done anything wrong or illegal? No. But he catalogs it. It keeps building, ladies and gentlemen. When you go through the event, all right, geez, it was at 10:54 hours maybe, he's told. Then it goes to 10:70. Does this person belong here or not? Okay, so the guy's gonna knock on the door. If you're waiting for someone, is it common sense to believe that someone will answer the door? Or that someone will turn on a light or anything at 2 in the morning if you're waiting for them? Of course it is. So does it make sense that no one does? No. And you have to put that in your mind. And he doesn't just do it once, he does it twice, loud. Mr. Pearson doesn't tell you that in his closing. He skips right to the garage. Twice, ladies and gentlemen, and no matter how much he gets paid an hour, $3.20 or whatever an hour, with regards to knocking on the garage door, Mr. Stoughton watching on this door, or whether or not it's a typo. I mean, ladies and gentlemen, for real? Okay, so then what happens? He comes back. Common sense. Adam Coy being reckless at this point, doing anything? No. Common sense. Hey, what's going on? Nothing. The guy goes, opens the car door, rustles around and grabs something. Officers are trained that that's an opportunity to retrieve something. They have to think in advance. They have to expect the unexpected. Is that an opportunity where someone might have grabbed a gun? Is that an opportunity where someone might have grabbed a weapon? Of course they had the opportunity, even on Mr. Stoughton's scale. Definitely could have gotten one there. Now, they're not saying he's doing that, but that goes in their mind because that's how they're trained, ladies and gentlemen. Then he comes by, goes, hey, what's going on? The guy just keeps walking. And then as he gets by him again, the gentleman keeps turning back, turning back. What are those? Are targeting glances. He wants to know where my client is. Again, you're not to consider the intent of Mr. Hill. That doesn't go in the equation, but the officer has to observe the body language. The officer has to observe the glances. They're trained that that's a potential threat indicator. That could be a danger cue. Call it what you want. That's good policing. That's not reckless. That's doing your job. Then what happens, ladies and gentlemen? He loses sight of him. As he loses sight of him, Detweiler pulls up. Okay, we now know when Detweiler gets out 10-4, we've gone over that. Detweiler, something's not making sense. It's weird. The years they've worked together. You heard Adam talk about a different burglary he did a month earlier. We walked into a house and the stuff's going, and people are tied up. So, ladies and gentlemen, something's not making sense. We have a duty to investigate at that point in time. Amy Detweiler testified she had a reasonable suspicion at that point in time that a trespass was going on because she saw the going like this, or something else was going on. And if she has a reasonable suspicion, Adam Coy has a reasonable suspicion, no matter what Mr. Stoughton claims. So at that point in time, they have to investigate. They don't get on the speaker and say, hey, we're about to walk up this driveway. Announcing it to everyone. That radio goes to everyone on the force. We'll let you know what happens. Check back in or get on the speaker in the car. That's not how they're trained. I don't know how Mr. Stoughton was trained. Stoughton was trained in Tallahassee, but that's not how they were trained here in Ohio and in Columbus. So then what happens? They approach, tactically they approach. Amy Detweiler to the right, backing off set. Adam Coy to the left, right? They tactically go through it like they're supposed to. What's Adam tell you? His intent is at that time. He believes the person went around back. So his intent is to go around back and find out what's going on, make contact, ask questions. What does he see? He sees a dark garage. At 2 a.m., a garage door open in the middle of the winter, 3 days before Christmas. And it's dark, and there's no light on there, and it's open. Okay, now we gotta check this garage. That's what he's doing. He's investigating. And ladies and gentlemen, the definition of a burglary includes a garage. And then when he comes around, he sees the shotgun, he tells you, he's crouched down in the way back of the garage. The way back. Is that consistent with, hey, potentially something might be going wrong? Of course it is, ladies and gentlemen. Of course it is. That Detweiler's got her gun out low and ready. That's how seriously she takes it. Adam doesn't even have his gun out at this point, ladies and gentlemen. As he's approaching, he's got the flashlight out as he's approaching. Hey, come out here, show yourself, show your house. What you won't see on the video is that the boss said he was facing that wall. Okay, he turned. Come out here, show yourself. Something's not making sense. He doesn't come out at first. And then he comes out, not fast, not slow, but they're both watching from different angles. And what does Adam tell you? I see him get closer to the car. It's a tight confines when you look in there. I see him turn towards us. What's that? Ladies and gentlemen, that's a cue. Waiting, whatever. Now, it may not be the part on the video that's there, but that's what he sees. And guess who else sees it? Amy Detweiler. She's coming up from straight ahead. And she says, yeah, I'm walking up straight ahead, and then I see the thing, but I see him turn. I can't see his right side. She has more of a straight angle at him than that. So in order for their theory to be correct, that he made this up after the fact, that means Amy Detweiler's in on this conspiracy. That means Amy Detweiler should be charged with accomplice to murder. And she's not, because it's a ridiculous theory. Because if you yell gun, gun, then Amy Detweiler's got to be in on it. Gun, gun, gun. If you say, hey, he's bladed this way and I can't see him, that means Amy Detweiler has to say, oh, I was on this side, but I couldn't see his right side. That means she's in on it. And the worst thing, ladies and gentlemen, would you ever turn your body camera on if you lied about this from the go? No. The government says Adam Coy, a Marine, or excuse me, an Army, 5 years honorable discharge, giving service to his country, a family person who has given his life to this community, made it up and lied, and somehow got Amy Detweiler in on it too. That's what has to happen if you believe their theory of why he shot, that he created the lie after the fact. What did Jim Scanlon say about the garage? There's a guy with common sense, right? Hey, do you want someone to investigate if you found out that your garage door was open and it was 2 in the morning and it was dark and someone was in there? Of course you all would. That's what we ask of the officers to do. But somehow that's reckless to the government. Somehow that's not doing your job. I don't care what's going on out there. Every single officer testified that an action beats reaction. Do you honestly want to base this case on a game that you used to play as a kid with hands here and hands here? Let's just look at that on his testimony. If you're playing that game with me, your hands are on top of me, right? You know that I'm going to try to hit your hands. You know that in advance. So you can anticipate moving yours. Right? If you guess right or anticipate right, it might happen. An officer doesn't know when a gun is going to be leveled at him or her. An officer doesn't get that warning. Hey, let's play this game. I'm going to do this, and then you tell me when you might. Are you going to draw a gun or not? No. That's how ridiculous his testimony is. A childhood game that you know an action's coming, but yet that's why he has to qualify an action. It's not really sometimes faster than the reaction. Use your common sense, ladies and gentlemen. Don't be distracted by that argument. Take your common sense back there with you to the jury room. Look at the jury instructions, ladies and gentlemen. Did you hear Mr. Stoughton say one thing about Graham v. Connor reasonableness factors? No, because he doesn't use them. You'll see in their terms whether or not the individual attempts to evade an officer. I don't know, is it more likely than not that when he walked away and he didn't answer, he was attempting to evade him? Could a reasonable officer believe that in this situation? It happened, ladies and gentlemen. It happened, and he went into the back of a dark garage into a corner. Furtive jet glances, sudden turns or justice. We have that here. Again, you can't make this up, ladies and gentlemen. This is the law of the Supreme Court. Ignoring commands. Yeah, hey, what's going on? Hey, what's going on? He's ignored. Partial commands, show yourself. There's a big thing here about show yourself, your whole body, come out. He had the left hand up, put the right hand up. It happened during investigation. You'll see that in there. The possibility that the suspect may be armed. You have to consider that. You have to consider that when he rummaged through the car. It goes through the equation. That's why they ask you to do it. The severity of crime at issue. Kevin Davis told you there's no more severe crime than someone pointing a weapon at an officer. Whether the suspect posed an immediate threat. An immediate threat. Now, it's not Seth Stoughton's definition of what an immediate threat is. You won't see that in the jury instructions. What you'll see is an immediate threat. Use your common sense. All of you have common sense. Immediate means immediate. You don't wait. And you'll have a jury instruction back there that if you believe by one witness, so one witness, Adam Coy, if you believe him more likely than not that it was an immediate threat and it was a reasonable mistake, your verdict must be not guilty. Now, we talked in voir dire, ladies and gentlemen, about corroboration, okay? And stuff of that nature, a smidge over 50%, more likely than not. We have proven to you, ladies and gentlemen, it's more likely than not reasonable based on totality of the circumstances without using hindsight 2020 and within the eyes of a reasonable police officer. Now, I don't get to argue again after this, even though we have a burden here. I don't get to argue twice, so I have to try to anticipate what they're going to argue after this. So I anticipate that they're going to attack Adam Coy's credibility because they tried to on the stand, okay? And what was that? They asked Mr. Davis, Kevin Davis, hey, if there was something different in his statement and his interview than he testifies on the stand, would you change your opinion? Oh, I don't know. You'd have to tell me what that is, right? I don't know. Right? So you can't change your opinion or address the opinion unless you know what the inconsistencies are, okay? So when Adam Coy testified, he testified that the first one, with reading the quotes. In his written statement, he said, yeah, put the quotes out there, something to that effect. I saw something to that effect. I'll be right out. I saw that stuff. Same in his tape statement. On the stand, he says, I could see the text bubbles. He told me he was coming out, and he said he told me she was coming out in his first statements, but I can't see it. I can't see that far. And then we go into the whole contact things and far away things. The concept he was explaining when he was allowed to, it's exactly what he said. That's their inconsistency, is that in a statement, a 10-page written statement and a couple-hour interview, the only inconsistency is that, oh, he said this, read the text, but on the stand, he said he just could see the bubbles. Case over. They proved their burden beyond a reasonable doubt. Just like that, ladies and gentlemen, just because of that credibility. Wow. Now, what was the second one? The windowsill. In his written statement and his statement, I guess, to the BCI agents, he said, yeah, he put the phone out like this, and he put the left elbow on the windowsill, and then he made an X. Okay. Well, geez, in court, he said, okay, well, you know, I saw the left hand go down here and make an X. Where would your left elbow be, ladies and gentlemen? On the windowsill. He was right that he rolled it down. He was consistent about that. He was consistent about the X, consistent about showing, consistent about what he said, but somehow that's a huge difference. Now, I got to ask Mr. Scanlon those differences. Any of those two differences, would that change your opinion in any way, shape, or form regarding the use of force? Absolutely not. Mr. Scanlon looked at me like I had 3 heads or something. He's like, what are you talking about? That's desperate, ladies and gentlemen. That's desperate. Now, we did something in voir dire, ladies and gentlemen, where I showed you, life and death situation. Count how many times the person in the white t-shirts passed the ball. Most of you had the wrong numbers. Half of you didn't see the ground. Okay? Are you lying about that? No, absolutely not. Because the human eye trains on different things. Body-worn cameras don't interpret what the human eye sees. They don't interpret what the human eye perceives. Now, I'm going to put you in a life and death situation now. For 27 minutes, the time that Adam Coy was there today, I want you to write a 10-page statement. I want you to be interviewed for hours upon hours. I defy any of you to only have 2 minor inconsistencies. Ten pages. Pages of information, and those are the inconsistencies. You know why there's no inconsistencies? Because he was there and he told the truth. Truth isn't a coincidence. Consistency and cooperation are not coincidences, ladies and gentlemen. It's consistent because it's the truth of what happened. Test his credibility. Look at all these questions. He had the audacity to hand it to my client and go, find in there where you said, down on his right thigh. Find in there. Hours upon hours, questions and answers. That's what they found. That's what they're saying. It makes a person who an honorable discharge not credible, and he made up this lie. They want him to be superhuman. Compare him to Mr. 320 an hour. So he's gotten about 12 grand before, plus yesterday 8 hours, plus today 8 hours, plus travel back, plus the other times he got here. We're at about 20 grand. And he sits at home and reads all the material when he wants, when he's not tired, and he gets wrong that there's a knock at the inside of the garage door, then there's a knock out at that door. Never happened. Well, I don't know, is there a door there or not? He didn't know what the hell he was saying. He's got typos about whether or not he asked for that type of stuff. He has missing information. But that's okay for the government somehow. You can't have it both ways, ladies and gentlemen. I defy anyone to go through that situation and come back and say, yeah, this is what happened, and not have some minor inconsistencies. Are you gonna have major? No, because you were there and it's the truth about what you perceived. Seth Stoughton had that information for years in his report. Years, and never bothered to review it or never bothered to correct any of the mistakes. We're talking about corroboration, ladies and gentlemen, right? That's kind of the concept. Who corroborated Adam Coy's credibility? Amy Detweiler, on her perceptions and what happened. He announced gun, gun. He told me to stay back. That corroborates it. Now, another example, we talked in voir dire about physical evidence, ladies and gentlemen, okay? And again, on the video, the part that's on there, you can't really see what's in there. You can't. If someone says they can or can't, I'm sorry. You can't tell, all right? Now, let's look at other physical evidence. The coroner, all right? They call the coroner because they want to put all those pictures up there and stuff like that. What's the real aspect of the coroner here, all right? I don't know if you were, we'll go over it. Remember, I kept saying the wrong thing anatomically. It's anatomically correct, right? So if bullet paths, anatomically correct, standing here like this, we know that the worst shot was right here. All shots were left to right, front to back, okay? Now this is using your common sense, ladies and gentlemen. Can't tell the order, can't say how the position the body was in, but let's go through some, all right? Right here, left to right, that's a bullet path. Okay, so if I'm standing this way, directly towards you guys, where must the bullet path be coming from? Over there. Who's over there? Detweiler. She doesn't shoot. All of them are left to right, the others on the leg. Left to right. Now, front to back. Some are upward, some are downward, depending on the position of the body. Okay, now, let's move it. What if, using your common sense, the person is bladed? What if the person is turned this way so that Amy Detweiler can't see the right hand? Where does that put the gun path, the bullet path coming from? Here. Who's there? Adam Coy. We know Adam Coy's shot. We know where he was. He was to the left of Amy Detweiler. Okay? So does the physical evidence of the bullet paths through the body, left to right, front to back, make sense? If what you see on the video is coming out right here, no, because that wasn't the angle that Adam saw. Because we know they had to come in this way, front to back, left to right. Same with those. Again, standing like this, the bullet path has to be from there. Standing like this, the bullet path has to be from here. Standing like this, the bullet path has to be there. We know no one shot from there. Use your common sense, ladies and gentlemen. Corroboration, ladies and gentlemen, of his perceived threat. Corroboration of he perceived a deadly threat and acted, and where people were, and the positionings of the body. Body-worn cameras, ladies and gentlemen. Mr. Davis testified at length, it's not what the eyes perceive. There's artificial lighting, the lens is different, it's a round lens, the positioning of the camera, that's why there's limitations. And he told you they don't normally match. What's on video doesn't normally match what an officer perceives and what an officer sees. That's why the limitations, but they want to rely on limitations. They want to rely on that. They don't want you to think about the bullet path and the position of the body and what Detweiler says. Just because something wasn't captured fully on the body-worn camera doesn't mean Adam didn't see it and perceive it. Video does not interpret what the eyes see. We all know the brain does. And you could be mistaken, as in this situation. Now, again, I've said this twice because there's a couple things you won't see in the jury instructions that's all Mr. Stoughton talked about. You won't see the word tactic in the jury instructions. You won't see it. And he was saying, that's not a good tactic. That's not a good tactic. That was an unreasonable tactic. You won't see it because it's not part of the analysis. You also won't see ability, opportunity, and intention as a definition of imminent threat because it doesn't belong there. He creates his own standard. Is it in Graham v. Connor? No. Is it in any others? No. It's not the law, and it won't be in your jury instructions. But even if you want to follow that down the rabbit hole, ladies and gentlemen, even if you do, more likely than not, break it down. Ability? Yeah, he had the ability. The distance and stuff there, Mr. Hill. Opportunity? Yeah. The opportunity to get a deadly weapon when he goes back to his car. And intention. Officers are trained, they don't even consider the intention of the suspect or the individual. You will not see anywhere in the jury instructions that you're to consider the intention of Mr. Hill, because it's not part of the analysis. And again, that's the hard thing to do. That's not a human thing to do, because we always think, well, what was the person's intent? What was their motive? What was this? What's behind the story? What's the real reason somebody did this? That doesn't come in this analysis, ladies and gentlemen. Now, let's look at the experts, just keeping it basic. Scanlon and Davis. Experienced? Beyond that. 37 years from one, 33 years from the other. Trained Columbus police officers and Ohio police officers? Absolutely. Scanlon trains all over the world. Practical? Yeah. Common sense? Yeah. Stoughton, how many times did Stoughton apologize? I'm sorry. I'm in academia. That's an academic term. That's an academia term. I'm sorry. That's the difference, ladies and gentlemen, that when you have real experience versus versus book, versus theoretical academia, okay? Because he deals in a different world, think tanks, things of that nature. He doesn't deal with the everyday, day-to-day stuff. He was an auxiliary police officer for 6 months and an officer in Tallahassee, and patrol's the only thing he ever did. Look at the demeanor. Look at Mr. Scanlon. The awards he won. A national award, top 10 law enforcement officers in the country. And I said, and he went into, well, I saved someone who was going to commit suicide at the top of a cell tower. I was lucky. I was lucky to catch him. That's Jim Scanlon. Humble, this and that. Most people are up there, oh yeah, someone was up there, I went up there, I saved, I was a hero. No, not Jim Scanlon, because that's how he looks at things. Practical, basic, using your common sense. Two experts train law enforcement officers. Their expert trains law students. And this whole thing about being a lawyer, like, ladies and gentlemen, none of you are lawyers. We trust you to understand the jury instructions and to apply them to the facts that the judge gives you. And we know that. And we believe in it. Now, I can't get back up, but I don't even have to anticipate what they're arguing because he argued it. Killed for following orders for whatever reason, God knows what. I think we've put that to rest, so to speak, or dealt with that. If you're gonna lie about this whole thing, do you turn your body camera on? No. If you're gonna yell gun, 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 would you yell gun, gun, gun if you didn't believe there was a gun there? No, because then you gotta bring Amy Detweiler in as an accomplice, because she's gotta say it, and the positioning of the body, the same things, okay? But even so, let's follow this down the rabbit hole that it is, ladies and gentlemen. Let's go down there. Adam admits to being nice, that the guy was fine to him. If you were making this up before you turned the body-worn camera on and before you, after the shoot, would you say, man, that guy was so threatening to me. He told me in the car he was gonna kick my ass. Then when he went over here, he said, F you, copper. Wouldn't you do that if you were lying about that to make it more believable? No, Adam admits to everything. He wasn't doing anything wrong at first. That's why I went back to my car. Have a good night. Are you gonna make up something about, hey, have a good night? No, you would say, oh, then the son of a bitch did this, he did that. Use your common sense, ladies and gentlemen. That's how desperate it is. That's, oh, man. Luckily, there's keys there. Gee, I don't know. I train people at shoot, don't shoot. Adam Coy. What happens when you're going to the course and you don't pass the shoot, don't shoot? You gotta come back and do it again. You don't get a passing grade if you make a mistake. When you make a mistake in life, in his situation, you end up in that seat, ladies and gentlemen. He's a shooting firearms instructor. He's done it for years. He goes through the patterns. He does it. Oh, I'm gonna make it up. Geez, I'm gonna make it up. Oh my God. So of course, he teaches people about these situations. So of course, he's gonna, is it natural to say, I gotta find what I missed. I gotta find what I missed. After the shooting, he goes into shock. He's dry heaving. He just took the life of someone because he believed the person had a deadly weapon, a silver revolver in his hand. And they think he has the wits and wherewithal to go, now I gotta make this up. Oh my God, there's some keys. There's the keys, there's the keys, there's the keys. Ladies and gentlemen, cooperation, okay? I don't know what they're gonna argue. I don't know if they're gonna argue that, hey, we can't tell if the things were in the pockets. Okay, their expert says, oh, he had keys in his hands. Mr. Stevens, man. So this one is Defendant's Exhibit 6, right? That's kind of a bigger view, right? And this is the government's. This one you'll have back there. Okay, oops, sorry. It's shot at a different angle, or I'm just showing you the depth, the two pictures. This one shows the actual all the way back there, right? But you see the cigarette there, and you see the cigarette there, right? Corroboration. I don't know if they're gonna argue, well, we don't know if the cigarettes and stuff were in his pocket. Well, we do, using common sense. Why? Because when he came out to the edge of the car, he fell forward. The keys and stuff were there. The cigarette pack was there. There's no way a cigarette gets way back there. Obviously, he probably had the cigarette pack and the keys in his hand and his right hand when he came out, okay? They didn't just fumble out of his clothing and stuff like that. I don't know if they're gonna argue about that. That's ridiculous as well, because the physical evidence shows. I don't know why the agent didn't pick up that cigarette. It's important because a pack of cigarettes is found out in front. So is it more likely than not that the keys were in his hand? Absolutely. Probably the cigarette thing too. The packets of cigarettes, I'm sorry. Cooperation, ladies and gentlemen. I'm surprised they didn't say he planted the keys. Okay? I mean, seriously, under that type of theory, that he made all this up? Oh, by the way, I'll turn my body-worn camera on, and geez, man, I hope Titweiler didn't turn her body-worn camera on. I better get to her, I better go watch that so I can do my statement. It doesn't happen that way. Ladies and gentlemen, we have met our burden. We've proven to you that his subjective belief of imminent harm or death is in fact reasonable. We've proven to you, ladies and gentlemen, that he responded with reasonable force based on the shoes of a reasonable police officer in that situation experiencing that. And we've proven to you more likely than not, one smidge over 50%, that the mistake was reasonable, ladies and gentlemen. We have proven that to you. Ladies and gentlemen, it's not lost on us that someone lost a son, a father, a friend. Okay, ladies and gentlemen? This case is a tragic case. This case has affected two sides. It's affected that side forever, that man forever, this family forever. It's affected you guys forever. You will have this with you forever. And then at the same time, we ask you to set aside your emotions and empathy and to analyze this as a clinician. And I'm sorry that we do that to you, but that's our system. It's a tragic case. And ladies and gentlemen, the only tragedy that can be averted here is a second tragedy. And that's if you allow yourself to follow that argument that he lied and created all this stuff. Because that's simply not credible, and that would be a tragedy. There's only one verdict in this case, ladies and gentlemen, and that is our client is justified, we met our burden. You can't, you shouldn't, and you won't allow that to go down that rabbit hole and not use your common sense and be distracted. We ask you to return a verdict of not guilty. I thank you for your time. I thank you for your attention. I thank you for your emotion. And I thank you, wish you Godspeed in your deliberations. Thank you.
Thank you, Mr. Collins. Okay, does anyone need a break at this point in time? Okay. Oh, yeah,
Could I have one, Your Honor? And also a moment with Your Honor.
okay. We're going to take about a 10-minute break, ladies and gentlemen, if we get you back in the jury room at 4:10. At 4:10. Okay, the admonitions that I've previously given you still apply. You're not to discuss the case with anyone or among yourselves. All rise for the jury. ladies and gentlemen. On behalf of the state.
Thank you, Your Honor. You've seen that. It was shown to you in voir dire about perception. He talked about it in his closing argument, defense counsel. But I look at this a little bit different. I look at this a little bit differently. This is how I look at it. Adam Coy shooting an unarmed man who was simply following his orders. That's what this gorilla represents to me. And all this other stuff, it's just noise. Blading, keys in the hand, cell phone up, showing text messages without being asked about them, not submissive enough. That's how I see this case as it relates to that. Mr. Hill being shot in this garage by Officer Coy, he's the gorilla. All this other stuff is just to distract you from what really happened. If Mr. Coy is not responsible for situations like this, then we got to be training our citizens to not listen and follow police orders. That's where we're at. It's exactly where we're at. Defense counsel wants you to believe that, show yourself and showing your hands means the same thing. It means the same thing, it's no big deal. Those things are huge. Those things are huge, especially when they result in the loss of life. How is Mr. Hill supposed to know that the magic words being used were raise both hands without anything in them, or just show yourself? We're taught from the day we start driving, sometimes before that, do what the cops tell you to do. Do what they tell you to do, and you can survive that encounter. That's not what happened here. Mr. Hill did exactly what he was told. And it may be loose language, lazy language on behalf of the defendant to just tell him to show himself. It may not matter to him. Show yourself, show your hands, whatever. You know who it mattered to? It mattered to Mr. Hill. That's who it mattered to. Now, I'm not saying that Detweiler's in on it. I'm not saying that she didn't testify truthfully. She testified that if she saw a deadly threat, she would react, and that she would shoot to stop the threat. Great. We want all of our police officers to do that. Key word, threat. There was no threat here. She didn't say, Mr. Collins didn't hand her a set of keys and say, if you see this, you're going to shoot. Would you shoot? He didn't say that. He said if you saw a deadly threat. And she said yes. She didn't shoot that night because she didn't see a deadly threat. And the circumstances surrounding it doesn't support thinking that a man in a garage holding car keys after exiting a car would be holding a revolver. You heard Professor Stoughton say this. He said, yeah, police officers get ambushed. Yeah, it does happen. But you can't use that as the industry standard. You can't use that as the norm. You can't use that just because it happens sometimes and you arrive on scene and shoot us all. It's contextual. Context matters. And it matters in this circumstance. Hindsight is 20/20. We're not supposed to be looking at hindsight. But you know who is looking at hindsight? The defendant. He's looking at hindsight. I'm not disputing the fact that he yelled gun, gun, gun. I'm not disputing the fact that he told Amy Detweiler, don't go there, we don't know where his hands are, something to that effect. I'm not disputing the fact that he patted him down. I'm not disputing that. That's why there was so much questioning about whether mistakes must be reasonable, or is it okay for an officer to just make a mistake? All three experts confirmed that if your officer is going to make a mistake, especially if it's deadly, it must be reasonable. Officers don't just get to walk because they make mistakes. But yes, they make mistakes, but if they're reasonable, that's when they're not responsible for the things they do. Here, this was not reasonable. I'm not saying he had a conversation with Detweiler about it. I'm saying after he killed Andre Hill, discovered that there was no weapon there, that at most, this man held a set of car keys, he has to figure it out. He has to find what he missed, according to his own words. And then he goes back and he uses his 20/20 hindsight to figure out, what can I point to that's suspicious? Oh yeah, he did talk to me when I didn't ask him. How is that suspicious? Mr. Hill was just being nice, and I'd be willing to say that if Mr. Hill hadn't talked to him first, Mr. Coy would have said, he didn't want to talk to me. He didn't want to talk to me. I found that suspicious. He didn't show me his cell phone that he was clearly operating. I found that suspicious. It's ridiculous to think that looking at Mr. Hill's actions, according to Mr. Coy, that Mr. Hill may be involved in a burglary. First of all, I found it interesting that the defendant wanted to walk away or walk back the fact that he said that he thought Mr. Hill was involved in a burglary. But we'll set that aside. I think it's a ridiculous proposition. Like burglars go knock on doors? You got the police outside, and you're gonna go knock on a door? That's not how burglars act. That's how someone who's waiting on someone acts. Oh, he was a lookout. He was waiting for someone inside. Oh yeah, you ever heard the phrase, no honor amongst thieves? If he was really a burglar, he would have hightailed it out of there. He was communicating with someone on his phone. He showed that to the defendant. Wouldn't he have texted the person in the house and said, hey man, I had to bail, the cops are here. You might want to leave. He didn't, he stayed there. If I'm shoplifting at Target and the police show up, guess what I'm gonna stop doing? I'm gonna stop shoplifting. And it would be clear that if this defendant thought that Mr. Hill was up to no good, he wouldn't have been doing the things that he was doing. It's more conducive to him waiting on someone than him committing a crime. Your Honor, can I get my computer here?
Yes.
Thank you. What would a reasonable officer do if he suspected criminal activity? Ask the person's name. We're supposed to believe that Mr. Coy felt that Mr. Hill's actions were so suspicious, he didn't even ask him for his name. He ran the plates and they came back. He didn't know if that was Mr. Hill's plates or not. How? Because he didn't even ask him his name. That is one of the lowest levels of law enforcement, is asking someone for their name. He didn't even do that. He didn't ask Mr. Hill for his identification. Hey man, can I get your ID? The neighbor out here is kind of concerned. I just want to make sure everything's good. Can I get your ID? He didn't ask that. He didn't do that. Why? Because he didn't think it was a big deal. Because he did not suspect Mr. Hill of committing any crimes whatsoever. Knock on the door to see who was present. He could have went up to 1062 Oberlin, banged on the door. It's a guy who's in a silver car. He says he's waiting on somebody in the house. Are you good? We good? That's all he had to do. Or bang on the door. Your garage is open. You're aware that this guy's out here. But no, he didn't do that. Why? Because he had no concern. He could have ordered Hill to come down. He said something to him as Mr. Hill walked up the driveway. Again, the police are outside. Now we have two cruisers and a man who he suspects is committing a violent crime, an aggravated felony, is just going to go walk up to the house when he has a car there that he could leave. It doesn't make sense. The story is made up to make Mr. Hill look like a potentially violent criminal so he can justify his reasons for shooting an unarmed man. Not that this is a big conspiracy, but the fact that he made a mistake and it wasn't reasonable. That's the cover-up, that he's trying to convince everyone that his mistake was reasonable. Because if Mr. Hill, if he is seen as you see him, as the evidence shows, he wasn't doing anything wrong. So then the defendant has a problem because he has killed a man who was in a place where he had the legal right to be without any weapon. He can't explain that away without talking about these things that really didn't happen. He could have used the PA system. Oh, we don't. We don't use the PA system for that. We don't use well, he didn't hear you. He didn't hear you. So you could yell louder. You could shine the flashlight on him and yell louder. You could use the PA system. Those are perfectly easy tools that you could use if you feel like there's a potential violent criminal not obeying your orders. You could ask to see Mr. Hill's hands as he's exiting the garage. Hey man, come here, let me see your hands. They act like that defense counsel acts as if that is prohibited language to ever tell somebody to see their hands. They act like that is not vernacular that police officers use. But he didn't have time. He did, but the expert did say he had time to say, something's not adding up, come here. But he didn't have time to say, show me your hands, dude, come here. He couldn't have said that? He absolutely could have. But the problem is that he did not view Hill as a threat, even at that time. Amy Detweiler said she had her gun out at a low ready. Why? Because she's approaching a dark garage. Nothing more than that. She's just approaching a dark garage, so she has her gun at a low ready. The defendant, he claims he didn't have his gun out at all. Again, he had no reason to think that Hill was going to do anything to him. And so it goes from nothing to deadly force without proper evaluation. And he's got to make up a cover for that. So then he uses 20/20 hindsight. He works his way backwards and thinks about all these interactions he had with Hill to justify that. Tell your partner, I think he could be dangerous, he could have said. As they're walking up, hey, this guy could be dangerous. I talked to him earlier, he may have a weapon. I talked to him earlier, they may be doing a bird. I talked to him earlier, there could be he could be a lookout for somebody doing something crazy in the house. You mean to tell me he's gonna let his partner that he's worked with for her entire career walk into an aggravated felony situation and not tell her about it if he actually had concerns? That's hogwash. He didn't have concerns. Tell my partner, watch my six, watch my back. I think he's casing the joint. Instead of doing any of that, what did he do? He shot and killed Andre Hill. He asked for water. Says, I gotta find what I missed. That's what he did. You don't need a use of force expert or an ex-cop or anything like that to tell you that if an individual police officer is with another cop, he's gonna warn them about a dangerous situation and say something other than it's weird. He didn't even say it was suspicious. You've heard all testimony from law enforcement people that said suspicious has a special connotation, meaning that you could interact with somebody a little bit more than just being present. He didn't even say that. It's not called reasonable weirdness. It's called reasonable suspicion. He didn't even say that. At best, Hill's actions were weird. They go on thousands of runs. Thousands of runs. He should know better, know how to operate and come into contact with somebody who has something silver in their hands after they just left a car. And I love how defense counsel kind of meshes things. We started off with Coy saying on the stand, I saw something metal in his hand. Right? That's the most he said. I saw something metal in his hand. He didn't say leveling. He didn't say I saw the glint of steel coming up at me. He didn't say that. He said he saw steel in his hand. Defense counsel gets up here and says, yeah, Mr. Hill started to raise his hand. And then we get to pointing directly at him. Come on. Come on. Those are all very, very different things. Mr. Coy on the stand said that Mr. Hill had something in his hand that looked to be metal. Could have been a pack of cigarettes, could have been a lighter, could have been car keys, could have been 1,000 other things. And again, I can't get away from the fact that if the defendant thought it was so important, all he had to do was say it. Even if you think he's a violent felon, even if you think that he's got all heck is breaking loose, you don't get to kill him for it. If they're following your orders, maybe you think, okay, he's being kind of weird. Well, I tell him to come here, he's coming here. He's following orders. He's beginning to comply. And I don't, partial compliance? Partial compliance? Are you kidding me? Partial compliance. He said, come here. The man, Mr. Hill, didn't yell at him, didn't curse at him. He started to go to where he was called. And he raised his hand with his cell phone, maybe to shine light so he wouldn't trip, maybe to say, hey, I know people sometimes get shot with phones in their hands. Here's my phone so you don't, get weird here. Defense counsel says he has keys in his hands, and the defendant says he saw something metal and he gets shot for it. Their own expert says, I asked him, what could be something that's not natural, that is natural human movement that someone can do that wouldn't be considered acute? He had a hard time with that question. And his answer was, well, if Mr. Hill would have came out of the garage with his hands, both of his hands up, okay, so Mr. Hill's in that garage, he's ordered to come out. What's he going to do? This? He's a dead man. He's a dead man. Because this defendant is going to say, well, he raised his arm at me and I saw something leveled at me that was metal. So Mr. Hill just showed the light lit phone. Also, maybe he was saying, look, I've already showed you this. I'm telling you, hey, look, communicating with somebody in the house. Defense counsel wants to make deal about Professor Stoughton never saying the words Graham versus Connor. Graham versus Connor, Graham versus Connor. The law of this case will be given to you by the court in the jury instructions that he's going to read to you when I sit down. Nowhere in there are you going to hear the words or see the words Graham v. Connor. You're not going to do it. It's not in there. Detweiler, defense counsel says Detweiler talked about how she didn't fall for the distraction. What distraction? The man had car keys. He wasn't distracting anybody. Was he wanting for her to not see the keys in his hand? He was showing up the cell phone to say what he was there for. The defendant had about a month to write his written statement and talk to investigators. About a month. He can come up, think about all these things, and get them all nice and tight. He had about a month before he said anything to anybody about a potential burglary situation happening in that house. Path of travel of the bullets. Defense counsel wants to say that because he was shot on his side, that it must have been bladed for Officer Coy to have access to that side to shoot him. Well, we don't know that the order of bullets. He was shot 4 times, some in the leg area and the body area. So you can see it on video, which I'm going to show here in a minute. If he gets shot or shot at, he could move. That's what the pathologists testified to. You can see it for yourself that there's no blading. He wants to make a big deal about Stoughton training law students. Well, Professor Stoughton trains law students, but he also trains police chiefs, police executives as well, law enforcement officers. Defendant's actions aren't consistent with a reasonable officer. And you've had experts testify about certain things. Well, the beauty about this is that it's your decision. You can believe any, part, all, or none of the experts' testimony. It is your decision to decide what this conduct is. And again, ladies and gentlemen, I keep going back to just because it is a threat does not mean that it is a legitimate threat. It does not mean that it is a reasonable use of force because someone is scared, because someone made a mistake. You can believe all you want that the defendant made a mistake, but that mistake has to be reasonable. And under these circumstances, it is not reasonable. I'm afraid of heights. I didn't fly my first airplane until I was 18. If I fly a plane and crash into a mountain, I should be criminally liable for that. Similarly, you don't get to be a police officer and shoot people and your only excuse is I was scared, or I was in fear, or I was mistaken, without it being reasonable. Yes, I am all for reasonableness of police officers and their mistakes, but when it's not reasonable, they must be held accountable. Remorse does not equal threat. Let's say if a witness saw a crime and they waited 30 days to give the details to police, wouldn't you have some concerns about the truthfulness of that statement? That's what happened here. Can I get my computer again, Your Honor?
You have it.
Let's talk about this for a bit and why it matters. Andre Hill's arm was blocking his lap. During trial, he said his left arm was on the window sill and his left hand was on his right knee, covering up his lap. During the verbal interview with BCI, he says Mr. Hill put his left arm on the window here, his left arm onto the window sill. Why is that important? Why do we care? We care because when someone's not telling the truth, it's hard to be consistent. It's hard to remember your lies and the things that you told before. Why would he make that up? Well, again, he said on the stand that his left arm was covering his lap area. Oh, because that would make him a little bit more suspicious. That's why that matters. That's why it matters. That's why we get that story that we got. Besides the fact of physical impossibility, I mean, he must have the longest arms in the world to be in an SUV and have his arm on his right knee. His arm was on the windowsill, maybe displaying both hands so nothing would happen to him. That's why it matters. He showed me text bubbles. That's all I could really see, sir. I couldn't read the text. That's what he said on the stand. And then he got into a back and forth with me because his written statement said he showed me his phone screen that had a text message on it and said, "I'll be right out," or something to that effect. My question was, the interviewer's question was in his verbal interview, did you see the text messages? His answer, he held it up and I seen something on there that said, "Be out in a sec," or "in a sec." Why does that matter? Because he's trying to make Mr. Hill look worse than what he really was doing. Because if he saw a text message, then that would justify why Mr. Hill was there. If he says Mr. Hill just told him that, then he could say, well, he could just be lying to me. I don't have to believe his words. Walked up the front of the driveway with Officer Detweiler. And I'm going to show you this in a second, this video. But, Your Honor, could I get here for a second? I had him look at A48. And he says that Mr. Hill was back here crouched down. Said he was back there crouched down. Remember that? Said he could see the cell phone light because it was crouched down back in this area. That's important when we talk about his trajectory of his path of travel. Because according to what he said on the stand, he said he went right up the driveway. And if you go up the driveway, yeah, you would be able to see all the way back there. But when we look at his body-worn camera, which I'm going to play in a second, you get this angle. The car is blocking him from seeing Andre Hill crouched down and seeing his cell phone. Why is that important? Because he's trying to make Andre Hill look like a suspicious, aggravated felon. But it just doesn't add up. Thank you. My computer again, please. Can I get the lights? Where he sees Amy. Out, they have a short conversation, and he goes up the driveway. He goes to the neighbor's house, Mr. Coy, and he's walking up the driveway. There's no way he can see back in the corner of that garage. There's no way. The car's in the way. He can't see back there. I'll continue playing. Oh, sorry. There's no way you can see someone crouched down back there. Not only is there no light, but also that angle. There's no way you would be able to see Andre Hill crouched down back there by his path of travel. Again, these aren't my words. I'm not making this up. He's making it up. You can see from the video. I questioned at trial, and did you see Mr. Hill? You said you saw a glimmer of light in the garage. Are you able to show from this photograph, State's Exhibit A48? Yeah, back over here. He was back over there, crouched down. Does not show that he is bleeding as he's walking out of the garage. It does not show that he is bleeding. My apologies, Your Honor. Could I get the lights dimmed again? Thank you. I'll fast forward. You'll have State's Exhibit H, which is what this is. Mr. Hill, walking as a normal person walks. I'll show it again. He is walking as a normal person walks toward a flashlight that is being shined in his eye. Clearly not blading. He's not in a boxer stance. He's just walking. Thank you, Your Honor. I'm done with the lights. State need not prove motive. We don't have to prove why Coy did what he did. We showed that he did it. We proved that he did it. Then they have the burden to prove that he was justified in doing it. It would be a death sentence for him moments sooner if we were to follow the advice of Mr. Scanlon of just raising both hands up in the air. When Mr. Hill went into that garage, it became his coffin. There was no way he could get out of there alive with Officer Coy on the scene. There was no way. There's nothing that he could have done. Anything he would consider a threat. Not a reasonable threat, not a threat from a reasonable officer, but him. No one has said and given Coy justification for shooting a man who was simply following his own orders. You've heard from defense counsel a lot in this trial, in their closing arguments. They don't want you to believe your own eyes. That's the video, the photographs, the impossibility of some of Coy's statements. They don't want you to believe your own eyes. I'm asking you to do just that. Believe your own eyes. Because if you don't believe your own eyes, if you ignore common sense, then you just might find him not guilty. But I know you have common sense. I know you trust your own eyes. And so when you go back into that jury room, take a look at this video. I didn't want to play it for you here. Take a look at it when you feel you can. And I'm going to ask you to do three things. Believe your own eyes. Don't check their common sense at the door. And follow the law. If you do just those simple things, I believe you will come to the decision that the defendant is guilty, that they have not proven the burden by preponderance. I thank you for your time.
Thank you, Mr. Pearson. Okay, ladies and gentlemen, at this time, I am going to provide you the instructions of law in this matter. All right, Mrs. Harper. I'm going to read these instructions of law. I'm going to ask that you read along with me while I do so. Members of the jury, you have heard the evidence and the arguments of counsel. It is my duty to instruct you on the law that applies to this case. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You're not permitted to change the law, nor to apply your own conception of what you think the law should be. The court cannot include all of the law in any single part of these instructions. In considering one portion of the instruction, you should consider it in light of and in harmony with all of the instructions. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he has been charged with a crime. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts in issue all the essential elements of an offense. The defendant is presumed innocent until guilt is proven beyond a reasonable doubt. The burden of proof for all elements of the offense is upon the prosecution. The defendant must be acquitted unless the state produces evidence that convinces you beyond a reasonable doubt of every essential element of the offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and any facts the court requires you to accept as true. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which the witness testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experiences of humankind. To infer or to make an inference is to reach a reasonable conclusion of fact, which you may, but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. The law does not create a distinction between the weight of direct and circumstantial evidence. You alone would determine the weight of any evidence, whether it is direct or circumstantial, based on its quality. You may not make one inference from another inference, but you may draw more than one inference from the same facts or circumstances. The evidence does not include the indictment, the opening statements, or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements and answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in the question that was not answered. The lawyers are permitted to stipulate that certain facts exist. This means that both sides agree those facts do exist and are part of the evidence. You are to treat a stipulation as any other evidence. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the test of truthfulness which you apply in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, his or her accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You're not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence should be the force and weight of the evidence, regardless of the number of witnesses on each side who testify to an issue. Also, discrepancies in a witness's testimony or between their testimony and that of others, if there are any, does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recall them differently after the passage of time. You are all aware of the fact that two persons who are witnesses to an incident may often see or hear it differently. In considering a discrepancy of a witness's testimony, you should consider whether such differences concerns an important fact or a trivial one. The testimony of the defendant is to be weighed by the same rules that apply to other witnesses. Generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Hypothetical questions may have been asked in which expert witnesses were permitted to assume that certain facts were true and to give an opinion based upon such assumptions. You must determine whether the assumed facts upon which the expert based their opinion are true. If assumed facts was not established, you would determine its effect upon the opinion of the experts. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the experts. In determining its weight, you may take into consideration their skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of all or any, or may be found not guilty of any one or all of the offenses charged. Count 1, murder. The defendant is charged with murder in count 1 of the indictment. Before you can find the defendant guilty of murder as set forth in count 1, you must find beyond a reasonable doubt that on or about the 22nd day of December 2020 and in Franklin County, Ohio, the defendant caused the death of Andre Hill as a proximate result of the defendant committing or attempting to commit felonious assault, an offense of violence of the first or second degree. Before you can find that the defendant was committing or attempting to commit felonious assault, you must find beyond a reasonable doubt that the defendant knowingly caused serious physical harm to Andre Hill, or caused or attempted to cause physical harm to Andre Hill by means of a deadly weapon. A person acts knowingly regardless of purpose when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You would determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that serious physical harm could result from his actions. Serious physical harm to persons means any of the following. 1, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. 2, any physical harm which carries a substantial risk of death. 3, any physical harm which involves some permanent incapacity, whether partial or total, or which involves some temporary substantial incapacity. 4, any physical harm which involves some permanent disfigurement, or which involves some temporary or serious disfigurement. 5, any physical harm which involves acute pain of such duration as to result in substantial suffering, or which involves any degree of prolonged or intractable pain. Physical harm means any injury, illness, or other physiological impairment, regardless of its gravity or duration. An attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon or possessed, carried, or used as a weapon. As a matter of law, the court instructs that felonious assault is a felony offense of violence and that it is a felony of the second degree. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose. Where an act is a crime, a good motive or purpose is not a defense. Cause is an act or failure to act which in a natural and continuous sequence directly produces the death and without which it would not have occurred. Cause occurs when the death is a natural and foreseeable result of the act or failure to act. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. If you find that the state failed to prove beyond a reasonable doubt all the essential elements of murder as to count 1 in the indictment, your verdict must be not guilty. If you find that the state proved beyond a reasonable doubt all the essential elements of murder as to count 1 in the indictment, you must consider by a preponderance of the evidence the affirmative defense of justification. If you find that the state proved beyond a reasonable doubt all the essential elements of murder as to count 1 in the indictment, and if you find that the defendant failed to establish justification by a preponderance of the evidence, your verdict must be guilty as to count 1. If you find that the state proved beyond a reasonable doubt all the essential elements of murder as to count 1 in the indictment, and if you find the defendant established justification by a preponderance of the evidence, your verdict must be not guilty as to count 1. Count 2, felonious assault. The defendant is charged with felonious assault in count 2 of the indictment. Before you can find the defendant guilty of felonious assault, you must find beyond a reasonable doubt that on or about the 22nd day of December 2020 in Franklin County, Ohio, the defendant knowingly caused serious physical harm to Andre Hill or caused or attempted to cause physical harm to Andre Hill by means of a deadly weapon. Knowingly has been previously defined, cause has been previously defined, deadly weapon has been previously defined, serious physical harm to persons has previously been defined, physical harm has been previously defined. If you find that the state failed to prove beyond a reasonable doubt all the essential elements of felonious assault as to count 2 in the indictment, your verdict must be not guilty. If you find that the state proved beyond a reasonable doubt all the essential elements of felonious assault as to count 2 in the indictment, you must consider by a preponderance of the evidence the affirmative defense of justification. If you find that the state proved beyond a reasonable doubt all the essential elements of felonious assault as to count 2 in the indictment, and if you find that the defendant failed to establish justification by a preponderance of the evidence, your verdict must be guilty as to count 2. If you find that the state proved beyond a reasonable doubt all the essential elements of felonious assault as to count 2 in the indictment, and if you find that the defendant established justification by a preponderance of the evidence, your verdict must be not guilty as to count 2. Count 3, reckless homicide. Defendant is charged with reckless homicide in count 3 of the indictment. Before you can find the defendant guilty of reckless homicide, you must find beyond a reasonable doubt that on or about the 22nd day of December 2020 in Franklin County, Ohio, the defendant recklessly caused the death of Andre Hill. A person acts recklessly when, with heedless indifference to the consequences, the person disregards the substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards the substantial and unjustifiable risks that such circumstances are likely to exist. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. Cause has been previously defined. Excuse me. If you find that the state failed to prove in a reasonable doubt all the essential elements of reckless homicide as to count 3 in the indictment, your verdict must be not guilty. If you find that the state proved beyond a reasonable doubt all the essential elements of reckless homicide as to count 3 in the indictment, you must consider by a preponderance of the evidence the affirmative defense of justification. If you find that the state proved beyond a reasonable doubt all the essential elements of reckless homicide as to count 3 in the indictment, and if you find that the defendant failed to establish justification by a preponderance of the evidence, your verdict must be guilty as to count 3. If you find that the state proved beyond a reasonable doubt all the essential elements of reckless homicide as to count 3 in the indictment, and if you find the defendant established justification by a preponderance of the evidence, your verdict must be not guilty as to count 3. As to counts 1, 2, and 3, the defendant, Adam Coy, maintains that his use of deadly force against Andre Hill was reasonable and lawful in the exercise of his official duties as a police officer, and therefore justified because he feared that the actions of Andre Hill would cause death or serious physical harm to the defendant. To establish defense of justification, the defendant must prove that he was justified in using deadly force by a preponderance of the evidence. Preponderance of the evidence is the greater weight of the evidence. That is evidence you believe because it outweighs or overbalances in your mind the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity. In determining whether or not an issue has been proven by a preponderance of the evidence, you should consider all the evidence bearing upon the issue, regardless of who produced it. If the weight of the evidence is equally balanced, or if you are unable to determine which side of an issue has the preponderance, the defendant has not established such defense. If the defendant fails to establish the defense of justification, the state still must prove to you beyond a reasonable doubt all the elements of the crimes charged. The standard of law to be applied in determining whether the use of deadly force by police officers is justified is as follows. Deadly force may be used if the officer reasonably believes that such force is necessary to defend himself from the actual use or imminent use of physical harm by the individual that poses a threat of death or serious physical harm to the officer or others. If such circumstances exist, then the officer's use of deadly force is not unreasonable. The test of reasonableness requires careful attention to the facts and circumstances, including but not limited to the severity of the crime at issue in using deadly force, whether Andre Hill posed an immediate threat to the safety of the defendant police officer or others, whether Andre Hill was actively resisting arrest or attempting to evade arrest by flight. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight. The determination of reasonableness must allow for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving, about the amount of force that is necessary in a particular situation. The test of reasonableness is not capable of precise definition or mechanical application. The reasonableness inquiry is an objective one. The question is whether an officer's action was objectively reasonable in light of all the facts and circumstances confronting him, without regard to his underlying intent or motivation. In evaluating reasonableness in the threat perception cases, other considerations may include, but are not limited to, attempts to evade the officer, furtive gestures and glances, sudden turns, and the ignoring of commands. Other relevant considerations may include the individual's demeanor, the size and stature of the parties involved, whether the individual was intoxicated and non-compliant, whether the individual is or appears to be violent and dangerous, the duration of the confrontation, whether it occurs during a chase or an arrest, the possibility that the individual may be armed, and the number of suspects with whom the officer must contend. Actual possession of a weapon is irrelevant as long as the officer reasonably believed that the individual possessed a weapon. The law does not require police officers to wait until an individual uses harm to confirm that a serious threat of harm exists. The objectively reasonable officer can be mistaken, even if the officer had a mistaken belief, as long as that mistaken belief is reasonable under the then existent circumstances. The officer is justified in using deadly force. If an officer reasonably but mistakenly believed that an individual posed a deadly threat, the officer would be justified in using deadly force. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged, your verdict must be not guilty. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts of this case, then you must consider the affirmative defense of justification. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts of the indictment, and if you find the defendant established justification by preponderance of evidence, your verdict must be not guilty as to counts 1, 2, and 3. If you find that the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts of the indictment, and if you find the defendant failed to establish justification by preponderance of the evidence, your verdict must be guilty as to such offense or offenses according to your findings. When you go to the jury room, you will have 6 verdict forms. I am going to read the verdict forms to you at this time. Okay, verdict count 1. We, the jury, being duly impounded and sworn to find the defendant Adam Coy guilty of murder as he stands charged in count 1 of the indictment, signed this blank day of blank 2024 by each and every juror, and there is a space for 12 signatures. The next verdict form reads, we, the jury, being duly impounded and sworn to find the defendant Adam Coy not guilty of murder as he stands charged in count 1 of the indictment, signed this blank day of blank 2024 by each and every juror, and a space for 12 signatures. The next verdict form reads, we, the jury, being duly impounded and sworn to find the defendant Adam Coy guilty of felonious assault as he stands charged in count 2 of the indictment. Again, signed this blank day of blank 2024 by each and every juror, and a space for 12 signatures. The next verdict form reads, we, the jury, being duly impounded and sworn to find the defendant Adam Coy not guilty of felonious assault as he stands charged in count 2 of the indictment. Again, signed this blank day of blank 2024 by each and every juror, and a space for 12 signatures. The next verdict form reads, we, the jury, being duly impounded and sworn to find the defendant Adam Coy guilty of reckless homicide as he stands charged in count 3 of the indictment. Signed this blank day of blank 2024 by each and every juror, and a space for 12 signatures. Next verdict form reads, we, the jury, being duly impounded and sworn to find the defendant Adam Coy not guilty of reckless homicide as he stands charged in count 3 of the indictment. signed this blank day of blank 2024 by each and every juror, and a space for 12 signatures. No inference is to be drawn from the order in which I have read these verdict forms to you. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of whether or not the state has proved the charges beyond a reasonable doubt. In the event you find the defendant guilty of one or more charges, the duty to determine the punishment is placed by law upon the court. You must not be influenced by any considerations of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of trial the court said or did anything that you consider an indication of the court's view of the facts, you are instructed to disregard it. Your initial conduct upon entering the jury room is important. It is not wise immediately to express a determination to insist upon certain verdicts, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide that you are wrong. Consult with one another. Consider each other's views and deliberate with the objective of reaching an agreement, if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest opinions in order to be congenial or to reach your verdict solely because of the opinion of other jurors. Before you can find the defendant guilty of a charge, you must unanimously agree on your verdict as to that charge. On behalf of the public and the parties, I would like to express my appreciation for your service in performing this extremely important public function. After your verdicts are returned, you may discuss this case with anyone, but you're not required to do so. Whether you discuss this case with counsel or anyone else after your discharge is a matter of your own free choice. When you retire to the jury room, you should select a foreperson. The foreperson will be responsible for the exhibits and the verdict forms and will return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her votes. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdicts are announced in open court, you're not to disclose to anyone else the status of your deliberations or the nature of your verdicts. If you have questions, write them on a piece of paper and give the paper to the bailiff. When all 12 of you agree on verdicts, all of you should sign the appropriate verdict form in ink and advise the bailiff by turning on the green light. You will then be returned to the courtroom. Alternate jurors were selected to serve in the event of any misfortune befalling a member of the panel. At this time, your service will not be necessary for you to begin deliberating. However, your responsibility to this panel, this court, and this case remain. You will be excused to return to the general jury room downstairs or another place designated by the court. The admonitions I have previously instructed still apply, and you must not discuss this case with anyone, conduct any research, do any investigation, or allow anyone to discuss the case with you while this jury panel is deliberating. You're not to tell anyone how you would have voted until this jury has returned a verdict. You are to remain each day until the panel is discharged. All right. A couple of things here, ladies and gentlemen. First of all, when you go back to the jury room and when you begin your deliberations, you will have all the exhibits that the court has admitted for your consideration. If I get a question requesting a certain exhibit that's not back there with you, my response will be, you have been given all the exhibits that have been admitted for your consideration, because there's a lot of things were discussed that will not be sent back to the jury room. Also, please understand that when you begin your deliberations, that deliberations can only occur when all 12 jurors are present. So in other words, if you're taking a break or something like that, and one of the jurors is late in returning, you can't say, well, let's just go ahead and get started, and we'll bring that other person up to speed once they arrive. Okay, deliberations can only occur when all 12 jurors are present. Okay, now, you're no longer on my schedule up to a point, but you're on your schedule. And what I mean by that is, if at any point in time you wish to take a break, you can take a break. It's just that you need to let us know that you're taking a break and for how long you wish to do so. In a moment, I am going to excuse you to the jury room for you to decide what time you want to return tomorrow morning. Okay? We're not going to start deliberations tonight. All right, so just let Ms. Harper know what time you're going to return in the morning. When you arrive in the morning, Mrs. Harper will let the alternates know who they are, and then she will instruct them as to where they can go. After the alternates have been instructed to, or have been placed someplace else, then you need to select a foreperson. Let Ms. Harper know who that foreperson is, and then at that time, you can begin your deliberations. Okay? Does anyone have any questions at this point in time about anything that I've said? All right. Take your notepads with you. Have a discussion what time you want to arrive tomorrow morning. Let Ms. Harper know. Once Ms. Harper lets me know, hold tight until I get back there. Okay? All right. All rise for the jury.
Take your number.
You may be seated, everyone. Okay. Any objections on behalf of the state with respect to the instructions as read?
No, Your Honor.
On behalf of the defendant?
None, Your Honor.
Make sure that Ms. Harper has the means to get in contact with you. We probably will let you know what time they're coming in the morning, so that you'll have that information. Once they figure out the time, Mrs. Manahan and I will go back, and I will provide the admonitions to them at that time before releasing them to go home for the day. All right. Are there any other matters at this point in time that we need to get on the record?
Can I address something in the back on property record?
Okay, that's fine. We can do that. All right. As always, the court is appreciative of counsel and their professionalism in conducting the trial. The court just likes to publicly thank counsel for how you've conducted and comported yourself during what obviously is a very difficult trial for all involved. Likewise, the court would like to thank those in the audience. At the beginning of the trial, it indicated how important it is for you to be able to sit through, again, a very emotional situation and do so without in any way doing or saying anything that might potentially influence the jurors. And the court is very appreciative of how everybody has conducted themselves during the trial. So thank you very much, ladies and gentlemen. All right. We are adjourned.
Thank you, Your Honor.
Your Honor, we should all, as a group, like to thank you, Your Honor, as well as Ms. Manahan.